All right. The justice of the Appellate Supreme Court First Department. Be here, all persons having business with the Appellate. Draw near to your tents and it shall be heard. Please be seated. Good afternoon and welcome to the Appellate Division First Department. We have over 5 hours of requested argument time today, and I therefore have to ask you to reduce your request to what you reasonably must have. People versus Arroyo. Submitted. No? Oh. I couldn't hear you. 2 and 1? Thompson versus Panic. How much time? No appellant? Do you want to submit? Is that a yes? Thank you. Matter of W. Children. Submitted. De Calibas versus Schimmel. You said 4 minutes.
Oh, I'm sorry, it's my sir. Okay, I'm going to request 5 and 2, please.
4 and 3. Claim Recovery versus Markel Corporation.
For appellant, 8 and 2, please. For respondent, I'm going to request 7 minutes.
6 and 2 and 6. People versus Roldan. Submitted. Aaron versus Leonardo.
I would like to request additional 25 minutes as an appellate.
Is there a respondent? No. So you're arguing against yourself. We're going to start with 2 minutes, and we'll see if we need more than that, because there's no one arguing against you. Baldy versus Abusi Law Firm is adjourned. Loughlin versus DeBarry. 6 and 2 and 7. People versus Yeo. Submitted. Needham versus Appellate Holdings.
For the appellant, Your Honor, 6 and 2. Your Honor, for a respondent, can I please introduce Scott Elton, who was admitted pro hoc in this appeal and would like to participate today. Thank you. 8 minutes for respondents, Your Honor.
6 and 2 and 6. People versus Sastry. Submitted. Basil Trading versus M&G Diamonds.
Appellant, 3 and 1, please. Respondent, 4.
Thank you. Reyes versus Groper.
Appellant, 5 and 2, please. Respondent, 5, please.
CFA Holdings versus New York State Liquor Authority. 5 and 1 and 4. People versus Dunkley. Submitted. Marte versus Lampert. Submitted. Okay, we're going to take a couple of cases out of turn because of recusals. The first case to be argued on which I am recused is Needham versus UpHealth. Judge Kapner has been vouched in.
That was weird. Hold on one second.
Of course.
Here's a secret one, when we sit in these chairs, we have different pads depending on, for tall or short, or so if you sit in somebody else's chair, it's like, oh, what did I sit on? But, it doesn't, okay. He gave you 6 minutes, correct?
6 and 2, yes, Your Honor.
6 and 2, okay, and he gave the respondent also 6? Okay, very good. Good afternoon, you may proceed.
Good afternoon, Your Honors. May it please the Court, my name is Ed Flanders, counsel for Plaintiff Appellant Needham & Co. Needham appeals from the dismissal of its claim against defendant appellee Appellate for indemnification and reimbursement of attorney's fees in Needham's breach of contract action against Appellate. Supreme Court's order should be reversed in Needham's second cause of action for indemnification.
How do you get around the seminal case of Hooper, which we've all cited many times for this proposition? I mean, there has to be some unequivocal statement in the agreement between the parties that they have to indemnify, otherwise we don't allow it. So where's the unequivocal statement in this addendum agreement that satisfies that?
Well, Your Honor, I think this court very recently addressed that very issue with respect to a similar indemnification provision in a decision written by Justice Moulton. And that is Shaw v. 20 East 64th Street, LLC, 198 AD 3rd 23. And that's a July 29, 2011.
Yes, counsel, but that, the provision there specifically referenced disputes arising from the owner's breach of any of its obligations under the agreement. And there's no similar language here.
Well, I would respectfully submit, Your Honor, that one little I of the indemnification provision here, in part at least, specifically deals with claims under the agreement. That's just like in Shaw. And in fact, 3 weeks ago, in the Seymour case, this court approvingly cited Shaw. And that case is Seymour v. Hovnanian. I don't think there's a reporter site for it yet, but it's 2022, Westlaw 17684/2009, and that's a December 15, 2022 opinion. And I know, Justice Moulton, you were on that panel, and that indemnification is very similar to ours because it, in part, talks about claims as a result of the execution or existence of the agreement. We have that same thing in subparagraph one little I of the indemnification provision. Who else can bring a claim under the agreement other than a party?
And counsel, are you also maybe stressing the point that that particular addendum part also says any and all, and then goes into the part that you're pointing to?
Yes, Justice Burke, you're quite right. It's a very broad indemnification provision to begin with. Any and all claims, right? And it's certainly not limited to any type of claims and certainly not limited to third-party claims. But again, I think that in addition to subparagraph one little I that specifically talks about claims under the agreement, you also have a limitation of liability clause in the indemnification provision. And that limitation of liability clause unquestionably applies to claims between Needham and Appellate. And other courts have held where you have a limitation of liability provision that is in close proximity to the actual indemnification language, then that shows an intent on the part of the parties for the indemnification provision to cover intra-party claims.
Speaking of another provision, what's the purpose of the notice provision then if it doesn't only apply to third-party claims?
So it applies to third-party claims, unquestionably. And I think you addressed this quite appropriately, Justice Moulton, in the Shaw case, because there you had notice provisions, you had assumption of defense provisions, and you said quite clearly that the parties' agreement, quote, provided intra-party indemnification, including attorney's fees, under the Hooper standard, even though other provisions apply to third-party claims. So you've got subsection 2i that clearly applies to only third-party claims, and then so obviously the notice provisions, the assumption of defense, the tender of defense, all of those provisions would certainly apply to subsection 2i. But with respect to 1i, at least that portion that talks about claims under the agreement, again, there is no other party out there that could conceivably bring a claim under the agreement. There's actually a no third-party beneficiary clause in the engagement agreement. And that was the reasoning that you laid out, Justice Moulton, in the Shaw case, right? It's the only party to which Needham's obligations run is Appellate. Appellate is the only one that can bring a claim, quote, under the agreement, end quote. And as a result of that, that is the unequivocal and, quite frankly, exclusive reference to intra-party claims that is required under Hooper.
Okay, we're going to hear from the adversary, your adversary, and you'll have a couple minutes in rebuttal. Okay,
Thank you, Your Honor.
thank you.
Good afternoon, and may it please the court. Scott Helfand here by permission on behalf of respondents. Your honors, there are at least three important problems with Needham's position. First, Needham overcomplicates things. The default rule is clear. It must be unmistakably clear. If there is any doubt, the indemnification provision doesn't apply. Second, Needham asks this court to do something no court has ever done, and that is rule that even though a notice, consent, and assumption of defense provision applies to every claim subject to the indemnification provision nevertheless applies here, where, as the Court of Appeals has said, such clauses are logically meaningless. To try and get around this, Needham cites the Shaw decision. Your honors, I'm sure have our briefing. You can see in the Shaw decision, there were two clauses. The notice and consent and assumption of defense provision specifically applied only to the clause that covered third parties. That's not the case here. The notice, consent, and assumption of defense provisions apply to any and all claims arising under the indemnification. If the indemnification applies, so do those clauses. Moreover, your honors, a third point, Needham's position is bad policy as well. The whole idea of the Court of Appeals standard, that it has to be unmistakably clear, that what the Court of Appeals just recently reiterated as an exacting standard, is that we have fewer disputes over where indemnification provisions apply, we have more settlement, and we have less waste of judicial resources. In fact, your honors, the whole point of the Court of Appeals standard is that if there is any doubt, then the indemnification provision doesn't apply. Recently, your honors,
I guess it's not unequivocally clear if there's any kind of doubt, right?
Exactly, your honor. That's exactly the converse. And your honors, recently the Court of Appeals, just while this briefing was going on, your honors, the Court of Appeals issued another decision in Sage Systems v. List, and that's 39 NY 3rd 27, 2022. In that case, the Court of Appeals reversed a decision finding an inter-party indemnification finding indemnification provision applied to an inter-party dispute. And the Court of Appeals specifically said, rejecting, respectfully, your honors, a lower court decision from this court that relied on Crown Wisteria, which is front and center in Needham's briefing, that to the extent any decisions that have come before this decision say that broad language by its nature suggests the indemnification provision applies in inter-party disputes, those decisions are inconsistent with the exacting standard that this court has laid down. Now, if I might very quickly, your honor, before my time expires, Needham cites a limitation on liability clause and says, aha, that must mean that the inter-party disputes are covered. No, your honors. As the Stevens v. Flexit decision from the district court said, which we cite in our brief, that provision is just as easily understood to require that if a third party sues both respondents and Needham, Respondents can't look to Needham to carry the bag unless Needham is engaged in gross negligence or willful misconduct. And otherwise, it's just as easily understood as applicable to a third-party dispute, and therefore it's not unmistakably clear. Moreover, Needham cites 2 clauses in the indemnification provision and says, aha, there are 2 clauses. One must apply to first-party disputes. Not at all, Your Honors. Needham ignores the actual language of the provisions. The actual language shows that both clauses, as the Voltus decision, which we discussed in our brief show, were concerned about third-party claims. Both provisions cover third-party claims. Needham doesn't cite any case with any language similar to either of the provisions here. Finally, Your Honors, as I noted before, the standard is clear. It must be unmistakably clear. If there's any doubt, Needham must lose. That is the rule. And here, not only is there not any doubt, but on top of that, to conclude in Needham's favor, this court must be the first court ever to conclude that the inter-party claims are covered despite the fact that notice, consent, and assumption of defense provisions apply to all those cases. And very briefly, Your Honor, one of the points Needham makes in its response is that, well, some of the cases we cite don't expressly include attorney's fees provisions. Well, actually, some of the cases they cite don't expressly include attorney's fees provisions. That's not the issue here, because the question in all of these cases was not whether attorney's fees were available under an all expenses provision. It was whether the indemnification provision applied in the first place. So in conclusion, Your Honors, Justice Chan issued a 5-page, single-spaced, well-reasoned decision. She addressed every single argument Needham makes here. Justice Chan's thoughtful decision should be affirmed, and as I noted, the court should follow what the Court of Appeals just reiterated in lists. The exacting standard, broad language is not enough. And with that, Your Honors, unless there are any questions, I will stand down.
Any questions? Okay, thank you very much, counsel. Mr.
Thank you, Your
Flanders,
Honors.
you'll have 2 minutes to respond.
So what I didn't hear Mr. Helfand address is the Shaw case or the Seymour case. And we are not just relying on the broad indemnity language here. We are relying on both the one little I, that's the first clause of the types of claims that are covered by indemnification. And those include claims under the agreement. Again, that is exactly the situation that we had, not just in Shaw, but even more so in Seymour, because Seymour didn't even talk about breach of the agreement. It just said claims under the agreement. And again, the only party that can bring claims under the agreement are the parties here, and the only one that can bring a claim against Needham is Appellate. So there is the clear and unmistakable intent, and all I'm asking this court to do is to follow what the court said in Seymour and in Shaw, because I do believe that that's a very well-reasoned decision. It is entirely consistent with Hooper. It deals with the fact that there are certain provisions that apply only to third-party claims. That does not render them meaningless simply because they don't apply to intra-party claims. So respectfully, Your Honors, I believe that Supreme Court's order should be reversed and Needham's second cause of action for indemnification and reimbursement reinstated. Unless the court has any questions.
Okay, I think not, so thank you both very much for the arguments, and we'll take another look at this.
Thank you.
Have a good day.
The next case is also going to be a case taken out of turn because Justice Kennedy is recused. Aaron versus Leonardo.
How you doing?
Go ahead. You know
Yeah,
that we have the briefs and the record on the case, so we have studied the case and know what it's about, so you asked for time, so I wanted to give you a couple of minutes to tell us anything that you feel affects the case in your favor.
Okay. Can you take another case and give me 10 minutes to just get my,
Excuse, I can't hear you.
can I take 10 minutes just to get my thoughts together, just to sit down?
No, this is your chance. Go ahead, you know the case.
Let me see, a judgment was entered against me on 8/3/21 by Judge Michael K. Kotz in a matrimonial divorce. In that case, I had filed a motion for reconsideration on the facts that facts that a default judgment was entered in against me by Michael J. Kotz. And in that decision, in that order, just too nervous, man, I'm nervous.
Mr. Aaron, and as I said, we have your brief, we have the other side's brief, we have the record. We'll study the case, and I thank you for coming in today, and
Just nervous, man.
okay. You've submitted papers, right?
Yes, I submitted,
So we have your papers. So thank you very much, and we're going to have to move on to the next case.
Okay, thank you.
Thank you, Mr. Aaron. Thank you, Manny. People versus Arahu. Wait for Justice Kennedy to return.
Good afternoon, Your Honors. Ashley Baxter for Appellant, Mr. Arujo, and may it please the Court. Your Honors, Mr. Arujo's sentence to a 5-year term of post-release supervision is excessive in light of his age, need for mental health services, and acceptance of responsibility. Here, Mr. Arujo could have received the minimum of 2.5 years, but instead he received a maximum of 5 years, and we're asking for that his sentence be reduced to the minimum in the interest of justice. Firstly, Mr. Arujo is a young father that lost his way because of mental health issues and being in an unsafe environment. Here, Mr. Arujo was homeless 3 months leading up to the incident. In fact, on the night of the incident, he had been temporarily staying.
Counsel.
Yes, Your Honor.
The factors that you've just gone through, they were known to the trial judge prior to sentencing. Is that correct? Right?
Yes,
All
Your
of these
Honor.
things existed prior to him being sentenced?
Yes, Your Honor.
So tell us something different that would matter, that the trial judge didn't know, that would matter in the interest of justice, because it seems to me that that would have been already considered.
Sure, Your Honor. In addition to all the mitigating factors that the court is aware of, as a respondent points out in your brief, under less is more, Mr. Arua's post-release supervision sentence would be reduced to the minimum, 2.5 years.
Go ahead.
I'll just finish.
Finish your thought.
Right. And so we are arguing that the fact that this would occur under less is more evidence that only the minimum was necessary in this case, and that despite less is more, this court still is uniquely empowered to reduce his sentence to the statutory minimum. Thank you, Your Honors.
Thank you.
Good afternoon, Your Honors. May it please the Court. Jennifer Cavallas for the people. Defendant's bargain for sentence was lenient in light of the nature of his crimes. Defendant shot a gun at his brother after an argument, and because of the nature of these serious crimes, we ask that you affirm the sentence. Defendant obtained a very favorable sentence for this plea. He received a statutory minimum of 3.5 years and 5 years post-release supervision. The above minimum post-release supervision is appropriate here because it balances against the fatal risk of harm that he posed to his brother by shooting a gun at him, and also accounts for the risks of Mr. Arujo's minor criminal history in his previous attempted endangering welfare of a child. Additionally, because of the Less is More Act, if defendant maintains his record of good behavior on post-release supervision, he will receive the exact sentence that he asked this court for, 2.5 years. He'll be released from post-release supervision as early as August of 2023. And as Your Honors noted, defendant's purported mitigating factors were fully considered by the sentencing court, and there's no reason to disturb them now. If there's no further questions, Your Honor, the people ask that you affirm. Thank you.
Thank you.
Your Honor, really briefly, with regards to the facts of the case, we just want to point out that it was not just one altercation. There were 2 altercations between Mr. Arua and his brother, and that Mr. Arua fired the weapon at the ground to scare his brother. This is what he told probation and the police upon his arrest. If there are no additional questions, we rest on our brief. Thank you, Your Honors.
Thank you. Thank you both.
Thank you.
The Kalibas versus Schimmel.
Good afternoon, Your Honors. Jillian Rosen for the plaintiff appellant. On this record, there are significant issues of fact with regard to defendant's strict liability for his knowledge of Lola's vicious propensity or proclivity to act in a way to cause harm to the plaintiff who was on the loop in Central Park. I want to just preserve the negligence claim if I have a chance on reply, as we know it's not recognized in New York. But with regard to the evidence on strict liability, I mean, we have abundant evidence. We have the
Counsel, what are the issues of fact that you're relying on? What are the issues of fact?
The issues of fact are defendant's own testimonial evidence or admissions that Lola does not respond to commands, that she's had complaints from neighbors in the building.
That was about barking, correct?
Not just about barking, it's also about lunging at the dog that it's barking at. In addition, he admitted that Lola doesn't respond to commands, and when she's giving chase, whether it's an object or a squirrel or any other animal, she does not respond to commands. In addition to his testimonial admissions, it got so bad that the building management sent a warning to the plaintiff that if this to the defendant that if this continued, Lola may need a muzzle. This is not a dogs will be dogs situation. So it's not just barking, it's lunging towards another dog, and it's also not, admittedly, not responding to commands. And I'll tell you why this is particularly significant. then I want to turn to the expert affidavit. In the context of this case, you are 40 feet from the loop where dogs are not allowed to be, and you're throwing a ball to a dog 40 feet from the edge of this loop. And not only are you throwing the dog not only are you throwing the dog, but admittedly, defendant is throwing the ball for purposes of training this dog. So this dog is objectively not even trained yet, and you're training this dog by throwing a ball 40 feet from the loop, which is the most heavily trafficked area for cyclists and runners and bikers.
Right, and there was also testimony, right, that the dog never chased any cyclists, any, other persons, right?
Yes, but you don't have, he testified that he never that Lola never ran into a bicyclist, but you don't have to have that exact act. What you have to do under Collier is show any act that might endanger the safety of persons and properties in a given situation. And here, as the expert says, and I can turn more to it on...
So the expert, Eric Albert, didn't examine Lola, is that correct?
Right, which we know that...
What is the impact of that non-examination on his affidavit?
Well, I think that it has no bearing for two reasons. First of all, as we know, even in medical malpractice cases, you have experts that don't examine the plaintiff but can opine based on their experience and the records. The expert in this case relied on defendant's own testimonial admissions, and it's at 329 and 330 of the record. If you look at paragraph 10 and 11, he says, I'm relying on the defendant's own testimony in addition to the complaints and the building warning that this dog was not responsive to commands, that he was aggressive, that he didn't follow the commands of the owner, and he had a high prey drive.
Counsel, I guess I'm just trying to understand how your argument intersects with the Collier case where it's vicious propensities that we're talking about, and you haven't, and I didn't read anything about a vicious propensity. It was a dog chasing a ball. What's vicious about that?
Well, first of all, there's no vicious propensities in Collier that was known to the owner, where here we have, the vicious doesn't have to be biting somebody or growling, showing their teeth. That's been established in the case law. It's any act that endangers the safety of another in a given situation. It doesn't have to be where the dog is jumping and mauling your face, right? So in this case...
Counsel, it seems that sweeps way too broadly. It embraces so much normal canine behavior that it's meaningless. So I don't understand what you're saying.
Well, I disagree with you respectfully. You want me to do it now or in reply?
Answer Judge
I only disagree with you to the extent that there have been cases, for example, the third department cases, Mature against Roy, there was a question of fact, and I'll give you the site. It's 174 AD 2nd 1020. It's a fourth department case. But the dog was found to have a proclivity for vicious propensity when it jumped in the pool. It jumped in the pool when an invitee of the house, a guest jumped in the pool, and the dog jumped in the pool afterwards. And that was considered a vicious propensity, a proclivity to cause harm because he had jumped in the pool in the past. So, or he had not jumped on somebody in the past, but he had jumped in the pool. So it doesn't have to be, vicious is not defined as something that is, vicious could be anything that causes harm, that endangers the safety of a person. It does not have to be baring teeth, jumping on the person. It could be the nicest dog ever, and in a certain circumstance like this, when it's ill-trained, okay, I'll take the rest up on reply. Thank you.
Good afternoon. May it please the court. Scott Kreppen with David Spellman Barrett for the respondents. The Doer case is on all fours with this one. It's the same location and a dog running into the bike loop in Central Park. The difference between the Doer case and this case is that in that case, the owner of the dog actually caused the dog to go into the bike loop. In this case, it was the dog that knocked his ball towards the bike loop, and then he chased it. So there's a break-in causation there.
Well, does it matter that they were playing at the proximity, as your adversary indicated, that it was so close to the loop that the dog wasn't supposed to be there? Does that matter in any way?
It would be on the fringe of something that would matter in a negligence claim, but we don't recognize a negligence claim. So as far as strict liability and vicious propensities, the dog was not being vicious. There's no evidence of vicious propensities. As Justice Moulton pointed out, that's every dog. To accept barking and being distracted by squirrels as vicious propensities would be to deem every single dog a vicious animal, which is simply not the case. A dog cannot be the nicest dog in the world and still have vicious propensities. Those two are incongruous. The expert affidavit we have here is based on nothing. The expert is basically opining as to what vicious propensities should be, which is the court's job, not an expert. They had a witness who claimed that there were issues, a neighbor they didn't get along with, but that person didn't submit an affidavit. And even there, they're talking about barking. They're complaining about noise. There's no issue of noise here. This is simply a dog chasing a ball, not being vicious, not doing anything, and not doing anything prompted by the owner. He simply chased a ball into the dog loop. It's an unfortunate situation, but there's no negligence by the owner. There's no negligence cause of action recognized in this state, and there's no evidence whatsoever of vicious propensities. Even if there were, there's no causal connection between any vicious propensity and what occurred in this incident. Thank you.
I want to talk about the expert affidavit, but before I do, this court in Anderson actually held that there was a question of fact as to the vicious propensity of a dog that rose up to greet people. Again, not biting, not, baring teeth, not clawing at the person, rising up to greet somebody. But at 3:30 of the record, this is what the, and by the way, Dorr is factually distinguishable because that only dealt with common law negligence. There was no strict liability claim. But at 3:30 of the record, I think it's really important, and this may be the best context of what Lola's proclivity was that led to, that's why it was vicious in this expert's opinion, which by the way is unrefuted. A dog like Lola that lunges after other dogs while leashed does not respond to commands from the owner to stop aggressive behavior, and where it has been suggested that the dog needs a muzzle, said dog should be kept on a leash, even a very long one, in public places so as to avoid the type of accident that occurred in this particular place. Lola has an uncontrolled prey drive and would not respond to human commands to cease reckless or dangerous behavior, including unintentional dangerous behavior such as running into the roadway as occurred here. So to answer your question, it's not just about throwing the ball. Where are you throwing the ball? Knowing what you know about this dog that doesn't follow your commands, that stalks squirrels and doesn't stop when you tell them to stop, and you're throwing it 4 feet from a roadway where you're not allowed to have dogs. This proclivity to endanger the safety of anybody on that loop is glaring to us on this record. It's not about, it's not about whether, it's not about just throwing the ball. It's about where you threw the ball and what you knew about Lola. And besides defendant's admissions that he couldn't control the dog, we have him actually issuing an apology to a neighbor, it's in the record, a neighbor who happens to be a dog trainer that had lodged complaints and said something specifically to the defendant and had wrote a letter to her apologizing. So you have a warning that I'm gonna muzzle your dog from the building. You have the defendant admitting that my dog doesn't respond to commands, and you have an expert that's unrefuted saying this dog has a high prey drive and should never have been off leash near the park loop. On these facts, on this record, on summary judgment, not on trial, on summary judgment, the trial court erred, and this case should be decided by a jury. To the extent of, I'm over my time, I would just ask you to look at our brief with respect to common law negligence and the reasons why we preserved it. Specifically, your case in Scavetta, how you had an issue with regard to the barred rule. If you have no further questions, I'll rest on my brief.
Thank you both.
Thank you very much. Have a great day.
Claim Recovery versus Markel Corporation.
Good afternoon, Your Honors. May it please the Court, Patrick Dressler here for the appellant. The central question in this case is whether the parties intended to be bound upon execution of the term sheet or whether they intended to be bound upon execution of definitive purchase and sale documentation. Luckily for the Court, the parties answered the question directly on the face of the term sheet. And of course, I'm referring to the effectiveness provision, like legal effectiveness. And that provision states unequivocally, quote, the parties intend to be legally bound to this transaction once this term sheet is mutually executed, not once final purchase and sale
Right,
documentation.
so you characterize the negotiation of the purchase and sale agreement as being performance, essentially, under the term sheet in your brief.
Essentially, yes.
But there was so much that was still handled about to come to the PSA.
Well,
Doesn't that just show that it was really, it was negotiation, that evinces negotiation, not performance of what the term sheet said?
well, it wasn't negotiation. What we'd say in the record is that, there was a period of time where Fulcrum was doing confirmatory due diligence. The PSA is exchanged in May. By July, Fulcrum is ready and willing to fund, and then all of a sudden, in August, Mr. Conca, who was the lead negotiator of the term sheet for Markel, is the chief claims officer. He gets wind that funds are increasing their price for these subrogation claims, these wildfire subrogation claims, and out of nowhere, he basically, what we think, extorts a purchase price increase out of Fulcrum. Fulcrum is completely shocked by it. You can see it in the evidence. They immediately say, whoa, the term sheet is binding. You agreed it was binding. These purchase rates were agreed upon and locked in as of the term sheet. The process we're going through is closing the transaction. That came out of nowhere. It's the same thing with the Stutman fees issue. You have to look at the record. By the middle of September, the parties have exchanged, quote, execution copies of the PSA. And then I think it's September 17th, 2019, the in-house counsel for Markel, Sheila Carter, she confirmed she has no further comments to the PSA. She sends the wiring instructions for Markel to facilitate closing. Then all of a sudden, Markel again gets a little bit of seller's remorse. What had happened was the engagement letter between Stutman and Markel should have been provided during confirmatory due diligence, but it wasn't. It's given to Fulcrum belatedly. Fulcrum, under the term sheet attorney's fees provision, which is very clear on who's responsible for Markel's subrogation counsel fees. It spells it out in mandatory contract-like language that's really indisputable. Fulcrum's responsible for any fees incurred after closing.
In your brief, counsel, you talk about Mr. Conca's statements both to your client and also internally.
Yes.
Why are those necessary to know? The statements that you use them to show that he understood the term sheet to be a binding agreement. Why do you need those statements?
You don't really need those statements. We would submit that the case can be decided on the four corners of the term sheet. Again, you're talking about a term sheet that in all caps at the front says, this term sheet is intended for the purchase and sale of claims and other related rights as set forth below. A term sheet that uses mandatory, contract-like language throughout. We're all familiar with contract language. What's the purchase price shall be? Markel will assign and pledge a first priority security interest to Fulcrum.
But the term sheet was also subject to negotiation and execution of a purchase and sale agreement.
That's correct, but under Stonehill, it speaks directly to that. Look, Kowalczyk of this court, the case Kowalczyk, Bed Bath & Beyond, Immigrant Bank, Stonehill of the Court of Appeals, they all make very clear that if you are trying to reserve a right not to be bound until execution of definitive transaction documentation, you must explicitly say so. You must expressly make that reservation. The court's not going to find a reservation like that in this record. In fact, they're going to find, you will find the exact opposite. What Markel stated at the time of execution of the term sheet was that we intend to be legally bound to this transaction once this term sheet is mutually executed. So it's actually the opposite of Kowalczyk, and I about fell out of my chair when I see the cases that they're relying on. First off, they rely on McGowan v. Clarion Partners. That case did not involve parties expressly stating their intent to be bound, and many of the cases they rely on, the parties actually expressly stated that they were not bound until definitive transaction documentation was executed. That's the world that my opponent and his client want to live in, but that's not the world that we do live in. They expressly stated their intent to be bound. Not only that, there's an entire agreement provision in the term sheet stating that the term sheet constitutes their entire agreement. And with respect to the subject to language, again, Stonehill teaches that that is a post-agreement requirement to consummate a sale. And that's exactly what the parties were proceeding to do throughout 2019 until Markel continuously got seller's remorse and ultimately killed the deal because they wanted to shove their attorney's fees, which under the term sheet they were clearly responsible for. They agreed they were responsible for pre-closing fees, and they wanted to shove those onto Fulcrum, and Fulcrum would not relent. A couple of other arguments that my opponent might make in a moment that they made in their briefing I could touch on. This proposed transaction idea. Look, the record makes pretty clear. It's in the cover email when Fulcrum sends over the term sheet for the first time. This is Fulcrum's, quote, proposal for Markel's subrogation exposure. It is a proposal. It's discussed internally for Markel, it's discussed between the parties on phone calls. Ultimately, it remains a proposal.
Ultimately, it's executed by both sides. You have time in response, so let's hear from
Okay.
you.
Thank you, Your Honors.
May it please the court, Damon Vokey on behalf of the respondent Markel. Just a couple quick things, and then I'll move
So
on.
as a general proposition, I understand if you enter into an agreement which provides that there are going to be further negotiations and there's got to be a further agreement, you would not typically think you're bound by that. But you have a problem here, don't you not? In that in this term sheet, as it appears on page 635 of the record, you say the parties intend to be legally bound to this transaction once this term sheet is mutually executed, which it is mutually executed. That's not in dispute. So you've obviously put in a provision into this term sheet which makes it unequivocally clear that you cannot walk away from this just by saying, well, we didn't agree later on.
Yeah, then I'll answer that. There were three things that Markel committed to. One, confidentiality. Two, and this is something they've never addressed in any adequate way, a standstill, no shop agreement, which is, and this is language that's critical, that it says, while the parties are negotiating this potential transaction, Markel won't seek and shall decline expressions of interest with respect to the potential sale of the subrogation claims. They've argued that's boot and suspenders and there's a binding contract, but this refers to negotiation of this transaction. It doesn't say we have a deal. It says while we're negotiating going forward, you're not going to go out and do a deal with somebody else. And in fact, Markel, and it's undisputed in the record, had better terms from other third parties than they had from Fulcrum. And that is a provision that they drafted. It was never negotiated, and it doesn't make any sense if you're going to give full force and effect.
Does it matter that Fulcrum drafted this? I mean, you're dealing with very sophisticated parties who are intimately involved in the details of the negotiation. Do we look to the fact that Fulcrum drafted this as becoming determinative under such circumstances?
I think you look at two things. One is the language, and one of the terms I just pointed out in the introduction section talks about the proposed terms and conditions whereby Markel would sell. And then you have it subject to both negotiation and execution of a proceeds agreement. So the language, we believe, is clear on its face if you're to give full force and effect to all terms. But the second thing, and a lot of the cases say you got to look at the totality of circumstances. The parties negotiated for 10 months. They went through open material items that were not addressed in the term sheet. One of which was, do we value these homes that went up in smoke in California on a depreciation value basis or on a replacement cost basis? And there was a dispute about that. After the term sheet, that dispute was negotiated intensively between the parties. But more importantly, and this is the one...
There was an agreement reached on those terms, was there
Yes.
not? But
Yes.
But then you wouldn't sign on to it at the end.
It was one of the material open items that was not addressed in the term sheet, which is the point I'm trying to make, is the term sheet left open material terms. But the most important one is the attorney's fees issue that came up after the term sheet was signed in due diligence when the lawyer had a program agreement providing for what he gets paid on subrogation claims. And it's undisputed that their general counsel in September, about 6 months after the term sheet was signed, said the business deal all along was we're responsible for the fees. What changed here is the lawyer threatened to put a lien on both Fulcrum and Markel on more than one occasion. And the term sheet says that we had to deliver these claims unencumbered, without a lien, without a deduction, without a set-off. And that led to months of negotiations between the parties about how to deal with the fee issue. And there never was a meeting of the minds on that. And again, in the due diligence provision of the term sheet, we had to be able to deliver these things free and clear. And we had a lawyer who wrote a letter on December 10th, 2019, 7-8 months after the term sheet, that said upon the sale to a third party, which was Fulcrum, I'm entitled to $18 million. That was a major deal killer here because it's not spelled out in the term sheet. And unfortunately, the parties could not reach agreement on it. There was an impasse. There was an offer for $650,000 plus a wildfire with and without a contingency fee. And Markel said the economics of your proposal to resolve open material items doesn't make sense for us. 3 days
Counsel, I like to
later,
go back because you say that the legally bound language is just limited to the confidentiality and standstill provisions, but how can that be when the term sheet indicates that this is for the purpose of buying, selling, or trading securities, and then once it's signed, accepted and agreed? So can you explain that?
yeah, there's 4 different points in this term sheet. There's no case on point here, and that's why I'm saying you got to look at the totality of the circumstances. If this was a done deal, you wouldn't have 10 months of negotiation. You wouldn't have an impasse on an $18 million legal fee. And one thing that's really important for the court to understand is no subrogation payments were made before they filed suit. So when you have a contingency fee arrangement, you don't have an obligation to make a payment on that until you actually receive the funds. That didn't happen before they filed this lawsuit almost a year after the term sheet was signed. And the legally bound, again, and when you read it as a whole, and you've got a standstill provision that's not in any of the cases they cite that says, while we're negotiating this deal, don't go out and do another deal with somebody else. We abided by that provision and the confidentiality. But you have to look at the 10 months of extensive negotiations and question, how could that possibly be if everything was signed, sealed, and delivered in March of 2019, and the parties go on for another 10 months?
Thank you.
Thank you very much.
Thank you, Your Honors. Yeah, just to pick up on a couple of points. Their entire theory of the legally bound language, they have no good answer for it. They say it applies only to the confidentiality provision and the standstill provision. Well, number one, that's not what the language says. It says you're legally bound to this transaction once the term sheet's executed, number one. Number two, the confidentiality and standstill provisions actually only speak to obligations of Markel. Markel keep this transaction confidential. Markel standstill provision. But the legally bound language speaks to obligations of the parties.
It also speaks of, uses the word agreement in the sentence before the legally bound sentence.
Right, it's a written memorialization of the parties' agreement.
Look, this is a very powerful paragraph in your side on page 635. There's no question about it. But then what do you say? He says, well, look, we've got this $18 million legal fee issue. How's that to be resolved? And how are they bound when you've got such a contingent issue outstanding?
Well, it wasn't a contingent issue outstanding. First thing I would say is the term sheet doesn't leave this item open. It says Fulcrum shall be responsible for any fees incurred after closing. Markel shall be responsible for any fees incurred before closing. So the parties contemplated this, and they spoke directly to it in the term sheet. That's number one. Number two, we cited undisputed evidence.
It's your position that it's not in a contingent, it's covered by the terms of the term sheet.
It's covered by the terms of the term sheet. What happened was that Markel was getting a demand from its contingency fee lawyer, Stutman. It was demanding its full contingency fee. Markel's in-house counsel, Sheila Carter, we cite this in the record, it's undisputed. She calls Fulcrum's general counsel, and she says, look, I've looked back at the term sheet, and we understand it's Markel's responsibility for the fees, but we want you to help us, quote, help us. And she says, we're not going to close the transaction with this issue hanging over us. And from that point on, Fulcrum considered contributing to the fees, but from that point on, it was Markel negotiating with its own subrogation counsel. There's a memo from Stutman Law Firm directed only to Markel. It's them negotiating with their subrogation counsel while Fulcrum is on the sidelines waiting for them to finish that process so they can close the transaction. This is a case of seller's remorse. They were trying to get out of the deal. They ultimately did kill the deal. And that's the case here. We would ask the court to reverse the order of the trial court, granting summary judgment for them and denying summary judgment for us. Thank you, Your Honors. Unless there's any other questions.
Thank you both.
Thank you.
Loughlin versus DeBarry.
it please the court? My name is Emily Ricebaum for plaintiffs, appellants Harry Rulin, Suzanne Laughlin, and James Satterfield. The decision below granting the motion to dismiss should be reversed and the complaint reinstated. There is no authority, none cited in the decision below, and none in respondents' opposition to support dismissal of either the fiduciary duty, the breach of fiduciary duty claim.
Counsel,
Yes.
On the fiduciary duty claim, we're applying Delaware law to this?
Yes.
Does Delaware law recognize a fiduciary duty for warrant holders? Or are you saying it's something different that we should be looking at as these plaintiffs?
Yes, there's something different here, Your Honor, in that these plaintiffs are shareholders. They are not just warrant holders. In connection...
Right, but the claims that they're bringing go towards their warrant holding, their options and things of that nature?
No, Your Honor, their claims that they're bringing go beyond just the warrants, and that's one of the fundamental errors in the decision and in respondents' opposition. Their claim, the scope of their claim is about the entire retaliation campaign, and that had 5 elements. There was the termination of Mr. Rulin and the demotion from his position as president of RECOR to executive vice president of a subsidiary. There was the refusal to pay...
Is that a breach of fiduciary duty? No.
Yes, it is, because he was a shareholder and he was unfairly treated. That's the entire
He was
element.
unfairly treated as an employee, is what that sounds like.
Well, we're talking about, that's one element, but we're talking about an entire context. And let me just take a step back. He complained, he filed a whistleblower, we're calling it a whistleblower complaint, against, regarding Mr. Berman, the CEO's conduct.
No, we know the facts.
Okay. In response, there was an entire campaign that went beyond any particular one element.
Yeah, but how does it affect him as a shareholder?
It affects him as a shareholder because he was treated unfairly as a shareholder. He bought...
He was treated unfairly, as Judge Moulton just pointed out, as an employee, not as a shareholder.
Well, except that his employment, he received his employment and his employment contract in exchange for when he sold his company to RECOR. And that package, there was a sort of a bundle of rights that he obtained, one of which was his employment, the other of which was shares, the other of which was the warrants. And as a whole, and this is what the court in Harada, which is a companion case that a Delaware court applying Delaware law found, that the entirety of the retaliation campaign caused a harm to these appellants as shareholders.
Why? When he's demoted, that affects his employment. When they don't issue the shares in response to the warrants, in terms of the value of the shares, isn't the effect of that to increase the value of the shares?
Well, Your Honor, but there's also the baseless lawsuit that was filed against them. I mean, that doesn't sit in a particular place. But the point is that that RECOR, DeBerry, and the directors were intending to harm the plaintiffs. They had a fiduciary duty to them because the plaintiffs' appellants were shareholders, and they were treated unfairly. There was a retaliation campaign.
Why isn't some of these matters that you're pointing to a matter of a breach of contract?
Well,
rather than a breach of fiduciary duty?
The filing of a baseless lawsuit is not the matter of a contract. The publication of a libelous statement is not the matter of a contract. It goes beyond any particular tort or contract. There was a widespread campaign targeting them specifically, and they were shareholders. And that
Counsel, maybe we should turn briefly to the defamation cause of action.
Okay, thank you, Your Honor. There's no dispute that defamation is well pled. The issue raised in court in the Gord case and raised here for the first time is the application of the qualified privilege. That does not apply here. And Gord court recognizes...
Wasn't RECOR required under SEC rules to disclose the potential rescission?
Yes.
They were, right? They had to do that.
Yes.
So doesn't that create, you can't show malice then. They had to do that. They had a duty to do it.
No, Your Honor, respectfully. They did not have to say that it was as a result of fraudulent inducement. The first element of qualified privilege is that the statement be fairly made. They could have, if required to, they could have said, these warrants are subject to rescission. We have a litigation about that issue. That might have been a statement fairly made, but to
You
go
don't
the
think
extra
someone
step.
looking at the 10Q statement wouldn't have a right to know that the basis is that it's a fraudulent inducement?
No, not in, if, no, they don't have that right. I mean, that doesn't give any other information than the plain statement that it is the subject of a lawsuit. If the person is really interested and wants to know what's at the heart of the lawsuit, they can go get the lawsuit in the Southern District of New
So
York.
they could say it's subject to litigation, but they couldn't say what the litigation is about.
Well, they couldn't say fraudulent inducement. If they wanted to say something less defamatory, they could have said that. I'm not here to rewrite what they should have written, but they might have said, we have a breach claim.
Thank you.
Thank you. Any other questions before I? Okay.
You have time in response.
May it please the court, your honors. My name is Jim Bonner. I'm here for the respondent, Paul DeBari.
Would you respond to the last point that counsel made that, well, yes, you had a right to put into the 10Q statement that there is an issue about these warrants, that they're in litigation, but going so far as to say that it's because there was a fraudulent inducement, that was not something you had a right to. Putting that in was not required to meet SEC requirements, and that was a libelous comment.
I would disagree with that, Your Honor. I think that the shareholders have a right to know why it is that there is a contention with respect to the propriety of the warrants and whether they're valid or not. And just simply saying that there is an issue as to it doesn't inform the shareholders as they have a right to know what is that issue so that they can make investment decisions, which is the entire point of an SEC filing. So it was very important for investors to know not only that there was some contention with respect to the validity of those warrants, but also just this one sentence, Your Honor, that there is an allegation of fraud, and that's why there is a question as to it. So I think—
How does that position reconcile itself with the Harada decision, counsel?
Harada, Your Honor, we would just submit is wrongly decided, and the best evidence of that is that the Second Circuit just considered every allegation that's in this complaint, and it just affirmed the dismissal of both the libel claim and, in addition, the breach of fiduciary duty claim. So we have inconsistent adjudications, one final having been affirmed on appeal by the Second Circuit, exact same complaint that we have at issue here, and it has affirmed the dismissal of both of those cases. So I would say Harada, unfortunately, wrongly decided, and that the much more recent Gore decision from the Second Circuit affirming Judge Lyman's decision from the Southern District is really a better precedent for the court to look at. And more importantly, it's a final decision, and as a result, it's res judicata or collateral estoppel with respect to all of the issues that are before the court right now. Harada, on the other hand, is a intermediate decision, hasn't been considered on appeal, and it was just with respect to the motion to dismiss, it doesn't have the same effect as the more recent Gore decision.
Counsel, you say in your brief that Ruland's complaint was found to be unsubstantiated. Is there any record evidence of that?
His complaint with respect to the behavior of
yeah,
Mr. Berman?
the complaint that's the basis for their overarching claim of retaliation. Ruland made this statement alleging behavior in the corporation. And you say in your brief that it was found to be unsubstantiated. Is that correct? Because they say it was just buried.
It's correct, Your Honor. There's a finding by the Board of Directors that this—
Where is that in the record, though, if you recall?
This is a motion to dismiss, Your Honor, and so there's not much for record here at this point. This case is going to trial in 2 weeks, and there's with respect to other claims, one of their 5 different litigations that are pending at this point in time. There's an abundant record in that case that Mr. Ruland's complaint was unsubstantiated. But let me go back to something that the court raised in the questioning of my opponent. The plaintiff claims that their breach of fiduciary duty claim relates to so much more than just their warrants. But the fact of the matter is, in their complaint, they calculated their damages to a penny, and those were the damages related exclusively to the value of their warrants. They've now invented this retaliation campaign, in quotes, and as my opponent said, there are 5 elements of that. And I think as the court suggested here today, None of those 5 elements have anything to do with their standing as shareholders. It's very important to note that there are 2 distinct lines of precedent that are interrelated in Delaware that negate the importance of each one of those purported elements of the retaliation campaign. Number 1, there are cases such as the 9 Systems case, the Chester County case, and others that we cited that say that if you're going to bring a breach of fiduciary duty claim, it has to be related to a harm that you suffered as a shareholder. None of these 5 relate to any harm that they suffered as a shareholder. Secondly, there's a case from the Delaware Supreme Court called Nemec, and there are abundant decisions that we cited in our briefs. And those cases say that if you have something, a right that arises out of a contract, that cannot form the basis for a breach of contract claim. So the 5 elements, just very quickly, Mr. Rulon was fired or demoted. That's a contract. It's in his employment agreement. That has nothing to do with a breach of fiduciary duty. I don't have a right to be the CEO of Apple because I have Apple shares. Number 2, we stopped paying interest on the notes. Same thing. It's a contract. If they have a complaint about it and they have brought these claims in the Southern District of New York, it relates to their contract claim. You can't transform that into a breach of fiduciary duty. Third, we didn't pay a bill that they submitted by their company that they formed after they left us high and dry, 1 year after they sold us Firestorm. We didn't pay that bill. That's a breach of contract. It's nothing to do with a breach of fiduciary duty. It happened after they left the company. Number 4, they say we initiated litigation. There's no right as a shareholder to be free of litigation with respect to your contract rights to have warrants and notes paid. And number 5, they say we defame them. Well, there's no right as a shareholder to be free of defamatory statements. They have a claim, and that claim renders this purported element of their breach of fiduciary duty claim totally irrelevant. It's not a shareholder's right. Very, very briefly, Your Honor, just to address the substance of the libel claim. They say for the first time here on appeal that the qualified privilege does not apply to them because it was made in an SEC filing, which many people have an opportunity to read. But that is absolutely incorrect. We have the Shandock case from the Second Circuit, and that's a case where there was a scientist who published false results. Her colleagues and her employers came out and they told federal regulators, and they published in 2 of the most widely circulated scientific journals that this person had engaged in research fraud. Now, those statements are much more broadly disseminated than an SEC filing, 1 sentence that probably no one ever read if they hadn't brought a complaint that related to it. And in addition, it's so much more devastating to the career of that scientist than anything that was said in our SEC filings. There are also issues, Your Honors, I know my time is up with respect to preclusion. The Second Circuit has reached a final decision. It's the exact same complaint. It's the same words. It's the same claims. It's the same alleged misconduct. It was just entered 3 months ago by the Second Circuit, totally considering all of the issues that are before you here today. And as a result, that decision, a final decision of the Court of Appeals sitting here in Manhattan, is the final word on all of these claims, Your Honors.
Thank you.
Thank you, Your Honors.
Thank you, Your Honors. The Gord case does not apply here. It is not the same case. In Gord, the court there limited the plaintiff's breach of fiduciary duty claim only to the warrants. It discarded all of the other elements of the retaliation claim. It did so, we think, wrongly based on an answer to 1 question at oral argument. That evidence does not exist here in this case. It does not exist in Harada. It is a different case. Gord does not apply here.
Didn't you assert Mr. Rulon's firing as a counterclaim in the suit brought by Raycor against you in federal court? You did, right?
Yes.
So how is it also, it's also a shareholder claim, his firing?
Well, no, that the claims in against Raycor are contract claims.
Nice.
But here we are suing the individual director, Mr. DeBerry, for a breach of fiduciary duty claim. Now,
Counsel, how do you address the fact that the damages you're seeking on the breach of fiduciary duty claim really is the value of the warrants, and there is no breach of fiduciary duty with respect to that?
the damages are not limited to the value of the warrants. The language in the complaint is they are at least the value of the warrants, but they are not limited to it. The damages here will go beyond. Collateral estoppel, just quickly, raised for the first time here on appeal. That is an absolute, that is an absolute bar. Not to mention that Gord is not, the issues are not identical, and there are inconsistent prior decisions. Now, and just on Chandok, again, that case, that was a case that involved scientific findings. There was no proof of malice here, where there was repeated efforts to work with the parties. Here, there is evidence of malice. We're on a motion to dismiss, Your Honors, and this court has repeatedly said that malice should not be determined on a motion to dismiss, and I know my time is up, but I refer the court to Harada, again, looking at the totality of the issues and finding under Delaware law that the alleged fiduciary breaches go beyond merely blocking plaintiffs' efforts to exercise or transfer their warrants, as defendants inaccurately state. The claim that defendants leverage their positions as corporate directors and officers for personal interests with no legitimate purposes are based on plaintiffs' capacity, not as warrant holders, but as shareholders. Thank you.
Thank you both. Basel Trading versus M&G Diamonds.
Good afternoon, Your Honors. Matthew Hurl for the appellant. Your Honors, we believe that the trial court erred in dismissing the complaint for all the reasons that the trial court cited. The primary reason that the trial court relied on was the statute of frauds. Although we believe the trial court correctly declined to apply the statute of frauds sought after by my adversary, the trial court on its own raised the issue of the performance within 1 year statute of frauds. We believe that the trial court slipped into the perhaps understandable but nevertheless erroneous mistake of looking to see what happened and then applying the statute as to what happened as opposed to what possibly could have happened.
But no partnership proceeds would have been due until the diamonds were sold, correct?
Correct.
So didn't the diamonds have to be improved? They were rough diamonds, and they had to be polished and made into saleable diamonds, correct?
Correct.
Is there any evidence in the record about how long that takes?
There's no evidence in the record, Your Honor. This, again, was a motion to dismiss. The pleading indicates that the diamonds were going to be purchased. The diamonds were purchased in May of 2009. They were subsequently sold longer than a year from that date. But that does not in any way, and there's nothing in the record to evidence the fact that the diamonds...
I mean, the third diamond was a decade later. It was finally sold about a decade later.
It was
That's
sold,
what we're fighting about, is the third diamond. Right?
Yeah, it was like 5 or 6 years later, at least. Oh. But the fact that was the third diamond. The two diamonds were sold more than a year after they were acquired. But there's nothing in the record that shows that they could have been not sold a day after they were acquired. The statute applies to agreements that cannot, by their terms, be performed within a year. There's nothing in the record, and again, this was a pre-answer motion to dismiss, indicating that these diamonds couldn't have been turned around and sold one day, 10 years, whatever. And so since it is not impossible by the terms of the agreement to perform, then the statute should not have been applied. On top of that, there is the general rule that partnership agreements are not subject to the statute of frauds. They can be oral, and the cases in this department have upheld that. We cite in the brief, but Prince v. O'Brien, 234 AD 2nd 12 of 1996, and cases subsequent to that do hold that partnership agreements are not generally subject to the statute of frauds. And only when they cannot, by their terms, be performed within that 1 year, are they subject to that 5701A1. Alternatively, the trial judge did mention 3 other bases, alternative grounds, the breach of contract. My adversary spends a lot of time arguing that there was no name for the partnership and that the partners weren't identified. We refer the court to the record on page 12, which I specifically identifies the partners, and the court also should be directed to record 30, 31, and 32, where there's documentation from the defendants to my client talking about 1/3 of 1/2 interest and partnership expenses, which we believe, established beyond a question, not that we have to prove our case at the pleading stage, but that there was a partnership here. Unjust enrichment, quickly, there is proceeds that went to the defendant that were rightfully my client's. If my client's not entitled to it, I ask rhetorically, of course, why would they get to keep the $400,000 windfall? How the unjust enrichment here is, if not my client, certainly not theirs.
Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. Mark Berman of the law firm of Ganfer, Shore, Leeds, and Zatterer, representing the defendants. We seek affirmance of the trial court's dismissal of the complaint below. These are sophisticated parties. They were represented by sophisticated attorneys.
Counsel, on the unjust enrichment issue, the plaintiffs contributed to the payment of the cost of the diamond, right, when it was bought? They contributed to that?
Yes, there were 3 payments, Your Honor, over a period of time, and then 10 years later, a breach of contract, unjust enrichment, and constructive
They also
trust.
provided expertise as to the value of the diamond and other things of that nature, right?
My client purchased the diamonds, and the plaintiffs provided some expertise with respect to the colorization of those diamonds, Your Honor.
So if we can agree that the plaintiffs conferred benefits to the appraisal, the purchase, the finishing of the diamonds, why wouldn't they be entitled to some sort of...
Let's get back to where we are, Your Honor, if you will.
Well, you can answer my question and then get back to that.
Oh, of course. The answer is you have to allege in a complaint for an unjust enrichment claim, wrongful conduct was done at the plaintiff's expense, that it was against equity and good conscience to permit the defendants to retain those benefits. Neither of those allegations were alleged in the complaint. The First Department is pretty clear. When you want to allege unjust enrichment, there are 3 elements, and those elements were not alleged. And an unjust enrichment claim, Your Honor, is dismissible, and this court does it every time when it's duplicative of a breach of contract claim. We have the same allegations, same alleged damages throughout the complaint for breach of contract, constructive trust, and unjust enrichment. I realize my time is up. I just want to spend 30 seconds on the statute of frauds argument and that Justice Moulton raised. There were 3 payments that took place. The breach of contract, or the alleged breach, was done 10 years later. There is an impossibility of doing it with 1 year. If one looks at the dates of the 3 payments, you have a check, a wire, and a check. This court could take judicial notice that checks take time to clear, and you can, a week later, cancel those checks. So the fact of the matter is, performance of the contract and the sale of the diamonds could not take place with 1 year, because as a matter of record and judicial notice, good funds were not provided to the defendants within 1 year. We made a very clear point, Your Honor, in the breach of contract claim. Who the contracting parties? M&G? Is it Inc.? Is it company? Is it limited? This court requires you to say who the breaching parties are.
They say all 4, and it's a pleading motion, Mr. Berman. So that's their argument. They say that, we'll sort that out on summary judgment, or we'll sort that out in discovery.
No, I think, Your Honor, at a pleading motion, you have to say it's Justice Moulton, Justice Kennedy. Who is the party here? You can't say collectively M&D. You have to say, and if you look at the hodgepodge of documents put together, you have invoices from Inc., you have checks made out to company, you have emails by limited, and you have affidavits that say the partner is the individual Roland Malakoff. This court is very clear. You have an individual or an entity. Liabilities are different with the individual and entity. And you have to make that clear, and this court has made that clear. In a complaint, you have to allege it. You just can't say collectively based on a hodgepodge of documents.
Thank you.
My time is up, Your Honor. If you have, are there any further questions, I'd be happy to answer them.
Thank you.
Thank you.
As Your Honor noted, the complaint alleges that the 4 defendants were the partners with the plaintiff. The 4 defendants and the plaintiff were a partnership, what we've called the sub-partnership of the main partnership. The allegation is there. The documentation supports my client paying hundreds of thousands of dollars towards the acquisition of these diamonds. The counsel is arguing we have to evidence how the money was spent and whether checks clear. At a pleading stage, Your Honors, respectfully, we don't have to do that. We've alleged all the elements of breach of contract, unjust enrichment. The court dismissed the breach of contract saying, well, the statute of frauds bars it, and so unjust enrichment's barred because I'm applying the statute of frauds. We submit to you that the statute of frauds has been shown not to be applicable, so the unjust enrichment is likewise not applicable. If it's duplicative of the breach of contract claim, they both can't, if the breach of contract claim is out, yes, you can't use unjust enrichment as an end run around a statute of frauds. However, you can have it if he's alleging there was no contract, no partnership.
You can argue in the alternative at this stage, is what you're arguing.
I'm sorry, Your Honor?
One can argue in the alternative at this stage, is what you're saying.
Absolutely, Your Honor. That is what we were endeavoring to do. And finally, with respect to the construction.
This is a case where they deny the existence of a contract.
They deny the existence. Well, I'm not sure what they're denying. I don't know if they're denying that there was a partnership or that the partnership was unenforceable because it wasn't written. Their own documentation says partnership expenses, 1/3 of 1/2, which in our mind memorializes the partnership agreement that we're alleging. So I'm not sure they're saying there was no partnership because I don't know how they explain that we gave them $250,000 towards purchase of diamonds. Why would we do that if we didn't have a partnership? What was the purpose of that if we weren't partners? We were giving our expertise and our money, and yet we're not entitled to they paid us when the 2 diamonds were sold, they paid us our share. We allege that too. They don't explain how, was that magnanimous or was there a reason there was? We submit the reason was there was a partnership that they acknowledged until they didn't.
Thank you. Thank you both.
Thank you very much.
Reyes versus Gropa.
Good afternoon. May it please the court, my name is David Metzger. I represent the appellant and the defendant, Jared Gropper. As the court is aware, this is just a hit in the rear motor vehicle case. The summary judgment was granted below by Judge Perez prior to any depositions. As I will explain and as was laid out in the brief, this is not a matter where I'm placing form over substance. In that the affidavit that was submitted by Mr. Gropper in the opposition did create legitimate questions of fact to deny the motion. But to begin with, the main issue is that the plaintiff had a burden to meet on the motion for summary judgment and did not meet that burden. And regardless of what was submitted, either contained in or not contained in the affidavit of Mr. Gropper in opposition, the case law is very clear that if the plaintiff does not meet the initial burden, that the summary judgment...
The plaintiff's affidavit that operating motor vehicle struck in the rear, right?
It does say that. It says, the exact quote, if I may, is, "I was traveling in the left lane of the express lanes eastbound in the state of New Jersey, and the defendant driver failed to properly brake his vehicle and struck plaintiff's vehicle in the rear end." Even by this court's own decisions, just saying that you were traveling and giving just a subjective opinion as to whether or not he failed to brake properly is not is not sufficient. There needs to be more than that, and I'm citing the Williams versus Kadri case, that there must be some explanation whether or not he was stopping, slowing, exactly what was going on. There's
They were
no,
traveling, the vehicle was moving, and then it was struck in the rear. I mean, I don't know what, but let's assume, let's put that aside.
Sure.
Mr. Groper, did he not concede or indicate that he struck the plaintiff's vehicle that was stopped for approximately 1 second or so? Isn't that in his affidavit?
his affidavit, we're not contesting that this is a rear vehicle strike case, but that does not mean that it's automatically summary judgment. His affidavit was that he was traveling 50 to 60 miles per hour in the left lane, 5 or 6 car lengths behind. The traffic, and this is very key, the traffic was light, it was moving well, and then for an unknown reason.
What is it that the plaintiff alleges the plaintiff did negligently?
What is it that the plaintiff alleges that my client did
What is it that the
negligently?
defendant alleges the plaintiff did negligently?
I'm sorry, Judge, I'm misunderstanding. What is it that the plaintiff alleges that my client?
What is the defendant saying that the plaintiff did? There's a comparative negligence issue here, isn't there?
There is, yes.
I mean, you are alleging, you are claiming that the plaintiff shouldn't get summary judgment at all. But let's suppose that the plaintiff does get summary judgment. Then there's an issue of whether there's comparative negligence here. So what is the comparative negligence that you're alleging?
Well, it's not entirely known, and that's why we need depositions. What was attested to in the affidavit is that there was a car in the center lane that had come into the lane but in front of the plaintiff, the lead vehicle, and we're not certain.
Does the defendant deny that version of events?
The defendant is the one that provided that version of events.
Right. He's conceding that. He's conceding
He's
that.
conceded that, but something caused the vehicle ahead to stop, something caused the plaintiff to take so long to stop behind that lead vehicle. We need depositions to explore it. There was really
This is all information which the defendant knows.
No, it's not information, respectively.
How long it took
He's behind the vehicle. It's not information that the defendant knows. The defendant, we need to explore, or it needs to be explored, exactly what the lead vehicle had in front of the lead vehicle, which there is no indication of it whatsoever in the affidavit. The affidavit's surprisingly.
Doesn't the defendant state that a car cut in front of the plaintiff, causing the plaintiff's vehicle to stop, and the plaintiff managed to avoid hitting the car in front of him, but the defendant hit the plaintiff's vehicle? Isn't that the outline of what occurred here?
It's not exactly what it said.
Where isn't it?
In that the car from the center lane went into the plaintiff's lane and then stopped suddenly. So something forced the plaintiff's vehicle, the lead vehicle that's not at all involved in this matter, to come to or to slow down or to do something that caused the plaintiff's vehicle. It's not just from my understanding and my reading of it.
Is that the plaintiff? Does the plaintiff bear negligence for that?
He may, yes. And there's certainly, if he doesn't bear negligence, it certainly goes to the issue of our client's negligence based on the cases, if I may finish, if I may finish.
Finish your thought.
So yeah, some of the cases that, or many of the cases that First Department has cited, or First Department has held, that when, including the Baez-Pena case, when traffic is flowing smoothly, and then all of a sudden there's a stop, and that's the testimony, or rather the affidavit of my client, that traffic was flowing smoothly. This is not one of those rear-end cases cited by the plaintiff, where, all of them, by the way, where there has been deposition testimony, where it's stop-and-go traffic, or where it's on a side roadway, or where it's in an intersection, or where someone has been stopped for prolonged periods of time. This was free-flowing traffic. This is not a unique situation, but a situation where this department has previously determined that that may not even be negligent on the part of my client, on the part of the rear driver.
Thank you.
Thank you.
May it please the court, Ryan Goldstein for the respondent. Your Honors, there's no facts in dispute in this case.
So I guess under Rodriguez, it certainly gets the plaintiff to summary judgment, this hit in the rear. But what gets the plaintiff to being entitled to have the comparative negligence affirmative defense dismissed?
Because both drivers agree that another vehicle came in front of the plaintiff, and the plaintiff was capable of stopping in time without impact, which is a stronger claim on behalf of the respondent plaintiff than your classic sudden stop defenses that we often hear about and this court often rejects. My client, as agreed to by Mr. Groper, the appellant, had to stop appropriately when this other car came in front of him, and he was able to do so. So why the defendant could not do so is because it's clear and obvious negligence on their part. And as you already pointed out, Your Honor, there's nothing before the court and before the lower court that evidences that the plaintiff respondent did anything to contribute to the fact that he was slammed into from behind by a vehicle that clearly was not doing the same job that my client was doing to avoid vehicles in front of them from stopping or cutting off or doing anything, because clearly my client did everything that you would expect a driver to do. When an other vehicle goes in front of his or her lane, they slow down or they stop as best as they can. And if the defendant appellant was doing the same job my client was, we're not here today, the accident doesn't occur. The appellant offered several arguments, one being that the police report should not have been relied upon by the court. The court clearly does not rely upon the police report, and the court didn't have to because the court specifically references the admissions by the defendant appellant himself to support the fact that this was a slam from behind on a vehicle that was stopped, and the result or the reason why my client had to stop is really of no consequence because my client didn't come into contact with anyone, but rather was hit from behind. So I think that this is one of the more simpler classic cases of a sudden stop defense that this court typically rejects, and I think this is another opportunity for you to do so. Thank you.
Thank you.
Just to address two of the things that we just heard that it was admissions by the appellant in the appellate brief or in the opposition. Again, it should not have even gotten to that point. What was in the opposition is of no moment if the prima facie case is not made out at the time of the motion for summary judgment. So the fact that it was an unsworn police report, that the fact that there was an affidavit with a paucity of any facts precluded the court from granting summary judgment to begin with, or to even look to what the defendant may have said or may not have said in the opposition. Counselor noted that both clients agree and then gave a factual explanation of what happened. There's no factual explanation. Again, the only thing that was before the court regarding the movement was that he was traveling in the left lane and that he was struck from behind. Everything that we just heard is counsel's statement of the facts, but is not the statement of the facts that was on the record or was before the court at the time of the motion for summary judgment. The plaintiff had a burden and did not meet it to make out the prima facie case. Thank you.
Thank you. Thank you both. CFA Holdings versus New York State Liquor Authority.
Good afternoon, Your Honors. Carlos M. Carvajal on behalf of CFA Holdings, the petitioner in this matter. And may it please the court, this matter is brought to review the termination of the New York State Liquor Association full board dated April 30th, 2020, which imposed significant restrictions on the petitioner's liquor license, which has caused substantial and, in some cases, irreparable harm to the business, which had been operating successfully and without incident for decades at the same
Counsel,
location.
it's a substantial evidence threshold, right?
Yes, it is, Your Honor.
Okay, so the credibility determinations of the ALJ, why isn't it game over at that point?
Well, for a variety of reasons, Your Honor. First and foremost, a substantial evidence record or standard also requires the finder of fact to take into account the whole record, which would also take into account any evidence that is favorable to the petitioner, and not only does it have to.
But are you asking the ALJ to like state, to sort of sift all the evidence like explicitly in his decision? I mean,
Well,
it was in front of him, right? It did happen. I mean,
Absolutely,
you
Your
heard the
Honor.
testimony.
And I can point to instances where the evidence that was provided by the petitioner was not given appropriate consideration or was entirely disregarded by the ALJ, which is part of the substantial record standard. And in addition to that, there's also the requirement from the I'm sorry, and this has been upheld both by 300 Gramerton Avenue Associates, which is cited by the respondents, as well as the Montel versus Kelly case in New York. So what I can perhaps point to the court is specific instances, and perhaps even the most egregious ones, where there was not the appropriate consideration given to evidence that was provided to the court. I can.
Well, why don't you give us a specific example?
Very well, Your Honor. I'd like to do so. For one, there was a violation that was rendered against my client, which said it was improperly operating as a nightclub. There was evidence provided to the court, to the ALJ, that not only was the application submitted by my client, which indicated that it was operating as a nightclub, has been operating as a nightclub, and has also been zoned for a nightclub for over 60 years in this specific location. This was completely ignored by the ALJ, and to make matters worse, was actually...
What did the license say?
Well, that's a bit of an anomaly, Your Honor, because the license says tavern, but tavern is sort of all-encompassing various different aspects of a bar tavern, which include dancing, DJ music, and 4 a.m., which fall under the nightclub provision of the licensing for the liquor license. So that's one. There's also
There were a lot of complaints that started coming in about this.
there were complaints, Your Honor, but I will say this.
Numerous complaints.
There were numerous complaints. None of them prior to 2020 turned into a police referral. The police referrals came after the fact, and we have evidence where it was the SLA, in fact, seeking the referrals. And this is an email that's part of the record, email from the sergeant in East Hampton saying to the SLA.
Does the record show that there were always complaints coming in about this?
No, the record shows, Your Honor, that my client had an impeccable record of 25 years himself and about...
But then complaints started coming in.
Only when my client had started having Latin nights at the location. That's when the complaints started coming in. And this was an issue very sensitive to the East Hampton Police Department, which was suggested undertake sensitivity training in dealing with minorities. So, you know, that's an issue that has been raised as well on the record. And again, Your Honor, there's specific instances where my client was accused of hiring an unlicensed security guard when my client hired a security company and provided the certificate of insurance.
But the fact is that the person who was there, Blemus, also had a felony record.
Well, Your Honor, he was not an employee of my client's. My client provided the certificate of insurance that the security company, Extreme Security, provided to him, and that was completely disregarded by the ALJ. Also disregarded by the ALJ was proof that the premises is located in a commercial area, but the decibel levels were the violations were issued on residential.
The evidence showed that the decibel level was 61.8, whereas it wasn't supposed to be more than 50 decibels.
Well, that's for neighborhood, Your Honor. There were two readings. The second one fell below the commercial decibel level, but again, the standard that was used by the ALJ was the neighborhood decibel level, and we presented zoning maps showing that we were in a commercial area. In addition, also the testimony given by...
Finish up because...
Yes, Your Honor. The testimony given by that officer shows that the law requires that the reading be taken from the property boundary. The officer, based on her testimony, could not have taken it from the property boundary because the property boundary is actually impeded by bushes, trees, and all sorts of shrubbery. She took it from the parking lot, which we submitted a map of the property and also Google photos showing that there is no way that the reading was actually taken from the property boundary as is required by the law. So these are just some of the most glaring examples where the proper consideration was not given to the evidence that was found to be exculpatory, that would have been found to be exculpatory to my client, and that is why the substantial evidence threshold was not met by the respondent. Thank you very much.
Good afternoon. May it please the court, Lawrence Schwartz, the New York State Liquor Authority. Your Honor, the appellant...
So what about that hearing, the decibel level, where the petitioner presented evidence that where the reading was taken from was blocked by bushes? What was the response by the Liquor Authority to that?
Well, the officer testified that she's very familiar with the area. She was standing where she was standing. The appellant's argument was that she could not have been standing where she said she was standing because there was dense vegetation at that point, and that would have precluded her from standing there and making the observations that she said she was able to make. The administrative law judge rejected that contention. He carefully considered it and rejected it. He found that the officer was credible, both as to the decibel levels that were recorded and also as to where she was standing when she took them. So this follows a pattern. The appellant continues to insist that the evidence that he presented was not considered either by the ALJ or by the commissioners of the board. I think there's a confusion between whether the arguments were considered and whether they were accepted. Even a cursory reading of the ALJ's decision shows that in every case where the appellant presented evidence, that evidence was considered. It was subjected to cross-examination, it was subjected to rebuttal, it was analyzed, and it was rejected in 21 out of the 22 charges. One other thing I just want to address off the bat, the appellant late in the game there were 27 complaints about this place within a period of just over a year. That included noise, fights, public urination, long lines, that kind of thing. Rather late in the game, the appellant claims that this is the result of these complaints being made on Latin night. Now, the appellant had every opportunity to bring in evidence to back that up. They had the opportunity to do it at the hearing. They had the opportunity to do it before the Board of Commissioners when they heard this case. There hasn't been a scintilla of evidence ever put forward that those complaints were made on Latin night. There wasn't any evidence that there was ever a Latin night. This is just a conclusory assertion by the appellant. Obviously, I'm not going to have time to go through this substantial evidence as to each charge, but just one thing I do want to address is that there was an availing charge here. This licensee basically sold the rights to this premises for 3 months to another corporation. He was paid approximately $250,000 in order to do that. And under the state liquor authority's rules, that is about the worst thing that a licensee can do. Under the case of DeLeon, a First Department decision, that alone is grounds for canceling the license. A much lesser penalty.
In this case, the license wasn't suspended or revoked, was it?
No, it was not.
There were
the
different
license was
penalties.
not suspended or revoked. There was a $50,000 fine, which has been paid, by the way, and then there were some limitations on the hours of operation and what kind of events that could be done here. So clearly, the reason I say this is because one of the points in the appellant's brief is that they claim that the penalty is excessive, that it shocks the conscience, and I just wanted to point that out. Again, under the availing charge, that's when a lot of these problems took place. But this licensee is still responsible for them. You can't just rent out the license and let somebody else use the premises. You're responsible for what happens during that time. And the licensee claims that they're not responsible for that because there was a clause in the written agreement with the availer that the availer was supposed to seek permission from the SLA to use the premises and that was never done. That just shows that they knew very well they weren't supposed to do this, and they did it anyway. And it follows a pattern. It's the same thing with the security guard company. You're not allowed to have a security guard who has multiple felony convictions. You're not allowed to employ that person. They claim that they're allowed to do that because, well, we used a third party to do it. We didn't employ the guard directly. We just hired another company, and we're not responsible for the personnel that that company brings up. I don't think that's what the legislature meant when it had that rule that you're not supposed to employ guards with felony convictions. I'm out of time. Thank you very much.
Thank you.
No more questions.
Thank you, Your Honor. Just very quickly, in regards to the availing charge, the availing charge resulted after my client entered into a management agreement, which he has used in the past previously. As I stated, he has been at that location for about 20 years.
You're talking about the turnover to BLIV?
Yes, yes, Your Honor.
How could they have done that, actually?
It's just a management agreement. My client who lives in the neighborhood was there at the property on a daily basis. This is not as the respondents try to portray.
But who was in control?
He hired managers. He had hired managers, but he had ultimate control. And when they were in breach of the management agreement, and again, this is something conveniently neglected by the respondent, my client put them on notice of their default prior to receiving any SLA violation, and terminated their management agreement shortly thereafter, based on their failure to cure the default. So whatever happened during the management, during the life of the management agreement, my client was on top of it and maintained a control of the part of the business. And one last point in regards to
Counsel, wasn't it bad from the get-go, though? I mean, he gave a license, or he availed a license to an unlicensed entity. Game over.
It was a management agreement. It wasn't availing. They weren't getting any of the revenue pursuant to the management agreement. They were supposed to manage the property, give him all of the revenue, which he would then disperse accordingly. So, and when they failed to do and maintain some of their obligations, the contract was terminated, and their default notice was issued prior to any violation being issued by the SLA. So it's not like we waited till the SLA came down on us. We were on top of it. And one last thing, if I may, Your Honors, much to do about the security guard. We certainly aren't looking to saying that we're able to hire such a person, but we knowingly did not hire such a person, and that's what the statute requires. It specifically says knowingly hired someone. We hired a security company. They were in charge of bringing in their security guards. They were licensed and insured, and unbeknownst to us, they had someone in there who was not licensed and had been a felon, and that is not a violation under the statute. Thank you, Your Honor. Any other questions? Thank you. Thank you. I never gave in my notice of appearance, officer. Okay.
Give it to Eric. Give it to Eric.